Good morning, everyone. It's 9:30 here, so I would like to go ahead and get started. My name is Erin Kopek, and I'm the Marketing Director for Extra Help, a workplace management resource. Today, you're tuning in to our workplace webinar that we do on a monthly basis. Today, we're going to be talking about medical marijuana in the workplace, and we have Courtney Cox from Sanford Phoenix Von Gothard, and he will be talking to us here shortly just about some information, and it's great information that he is going to share. Before things begin, I would like to give a little tips on how it's going to go. The call will last close to 1 hour. You are currently set up as listen-only mode, but there will be an opportunity to ask questions at the end. Questions can be posed throughout the presentation. Feel free to type those questions in or the chat messages in as the presentation continues on, and we will answer those questions as they come in. So let's go ahead and get started. Courtney Cox joined Sanford Phoenix & Von Gothard in 2010 as a shareholder. Prior to joining the firm, he was a United States Attorney for the Southern District of Illinois, where he oversaw 35 assistant U.S. attorneys along with other staff who served the federal district that covers the southernmost 38 counties in Illinois. Courtney was appointed to this position by the judges of the United States District Court of Southern Illinois. In this capacity, Courtney served as the Chief Law Enforcement Officer and was one of the founding members of the Violent Crime Task Force, an organization dedicated to reducing violence in the East St. Louis area. Before assuming the duties of a United States Attorney, Courtney served 25 years as a private practice attorney in his hometown of Benton, Illinois. Here, he concentrated his practice primarily in civil rights and employment law litigation in federal court, and has successfully represented numerous businesses in Southern Illinois. Please feel free to ask questions. Like I said, we will go ahead and get started and turn the floor over to Courtney.
All right, Erin, thank you. I want to begin by thanking you all for being here with us today to talk about an interesting and very topical topic. And I also want to thank Extra Help for organizing this. This is a great way to get some information that hopefully will be useful to you in your work. As Erin indicated, I was the chief prosecutor for the Southern District of Illinois for the federal system for about 3 years, and so during that time I prosecuted a lot of people for various drug offenses, including marijuana, although I will tell you that marijuana turned out to be one of the least problem drugs that we had in our district and in most districts, with the up-and-coming use of heroin and prescription medications taking most of our time. So we were seeing fewer and fewer cases involving marijuana, especially marijuana in small amounts. Generally, the federal prosecutors only prosecute marijuana in certain large amounts, except in some unusual cases. So, for example, I think in one of the western states you have to have 5,000 pounds of marijuana to be prosecuted. That doesn't mean you won't be prosecuted by the state. And so the theme during today's talk will be that while marijuana is legal for limited medical use in Illinois, it's still a Schedule I illegal drug for all purposes, even medical use in the federal government. And we will talk about that as we go through. That's significant for employers and for employees to understand that as they work through various policy decisions and disciplinary decisions. So let's go ahead and get started. Just remind you that our firm, I'll put a little plug in here before we get started, our firm has over 100 attorneys, and we have a significant employment law team and labor law team that I'm a part of. I live in Benton, and the various members of the team are in our various offices. So if you have a question, just feel free to contact me, and we'll be glad to try to help you. Illinois has a, let me go back here just a minute. I'm learning to use the equipment. Just a moment. There we go. And so what we're seeing here as we go into this 4-year pilot program in Illinois for medical marijuana is that we're going to see a conflict arising between employers and patients. Patients have certain rights under this act, and employers have certain rights under the act and also under federal law. And in fact, employers have certain obligations that they're going to have to fulfill. So what we're going to see as we go through this presentation is that there will be points of conflict between really the federal and state law between employers and patients. The legalization occurred on January 1st, 2014. It's called a pilot program because it's going to last for 4 years. I will almost guarantee you that it will be extended beyond that time. And in fact, we're seeing recently I read an article that talks about the change in the law that will make a possession of 30 grams or less punishable by only a $100 fine and no jail time. So we're seeing we're going to see a gradual change, I think, in not only in medical marijuana situation, but also in situations where there's just recreational use of marijuana. So while this is a pilot program, I think we're going to see it continue. We're about halfway into the program, and we do not yet have any people that are authorized under the program, I think, to either grow it or use it. And as I understand it, people who have the last names A through L will sign up in September and October, and the rest of us folks will be in November and December. So we don't yet have any facilities, I think, that are producing. All medical marijuana that's used in Illinois for this purpose has to be grown in Illinois. It won't be imported. And so there are a lot of steps that have to be taken before it's even implemented. But I think it's good for employers to be ready and think about how they're going to handle this situation when it comes. Illinois is the 21st state to legalize this, and it is the most strict use of medical marijuana of any state. And while some states have similar programs, this really is the most strict program in the United States. I believe that as they go through the pilot program and move into what I think will be a more permanent program, I think we're going to see that loosened up a little bit as time goes by. So let's talk just a little bit about who can use marijuana, at least under Illinois law. And again, I want to remind you that under federal law, nobody can use it. It's illegal for any purpose. But in Illinois, we have definitions in the Act, and one of the definitions is for who can be a patient. A patient that's going to use medical marijuana has to be registered and qualified. Qualified means you have to be diagnosed by a physician as having a debilitating medical condition. And I think there are about 30 different conditions that are listed that, for example, glaucoma, cancer, HIV, and certain specific reasons for using marijuana, not just general medical condition. So a physician has to first give you a diagnosis, and then you have to be registered, which means you have to register with the state. And I think that they lowered the cost of applying for that. I think it it was $150, and I think that's been reduced to $100. Veterans and people with disabilities would pay $50. So there is a fee to sign up for that. Now then, they have I've not quite figured out how this works or why this is important, but they have what's called a registered designated caregiver. And this person has to be licensed or registered to assist the patient in using the marijuana. And I'm not certain what they would do, and I haven't found any explanation about that. I can see if you have somebody that's severely disabled, may not be able to use the marijuana themselves, and we need some help, but I'm really not certain how this works. But we do know that the person who is a designated caregiver has to be 21 and cannot have a conviction of an excluded offense, and they can only assist one patient. They can't make a business, in other words, out of assisting people with medical marijuana use. So I'm not quite certain how that works and what the purpose is, but as we get into the program, maybe it will become more clear. Now then, there is a provision in the Illinois Act that prohibits an employer from discriminating against a person solely, and you can see I've highlighted on this slide here the word solely, for his or her status as either a registered qualifying patient or a registered designated caregiver. I'm not sure what that means, except that I guess if you have other bases for discriminating against that person in addition to this one, it's okay. We do not yet have any cases that explain to us what this means, but I think we will see cases emerge as we get into the Act and the use of medical marijuana, and we see what employers are doing. And as we go on here, I think you're going to see why this is even muddier than it appears to be here. But the Act itself does say that it prohibits an employer from discriminating solely based on that status. Now then, the question I've asked myself, and I'll present to you here this morning, is by using the word solely, did the legislature mean that that's only one of the reasons, among others, that the discrimination is permissible? I don't know, and we'll have to rely on the courts to probably tell us that. Now, one of the things that the Act does say that sometimes it's okay to discriminate against people on the basis of this their use of medical marijuana. An employer is permitted to discriminate if failing to discriminate causes the employer to violate federal law. And for example, one of the more obvious examples would be a truck driver with a CDL, and that's more regulated by federal law. And so what we're going to see is a number of employment positions that have a relation to federal law, or maybe contracted to federal government, or all sorts of things that are going to raise a lot of problems and present a lot of conflicts between people who want to use medical marijuana, but their specific job position by reason of federal law would not permit that. Here's Dr. Gupta, and most of you have seen CNN, the big show, not too long ago, when he came out and said pot is okay. And that's caused a lot of movement, I think, in pushing forward by various groups to legalize marijuana completely. And I don't know that we're going to see that happen in the federal government anytime soon, but we clearly are seeing that happen in state governments in quite a number of states. So what can employers do once this act really gets going? So generally we see employers sort of wringing their hands, oh no, now we don't know exactly what we can do and can't do, and how do we stay out of a lawsuit or some sort of claim and avoid issues. So here's some tips. You can prevent persons from smoking marijuana on your property where your business is located. You have the right to do that. Just because a person is a designated patient under this act and can use medical marijuana doesn't mean you have to allow them to do it on your property. You should have a policy in place that says you cannot do this. And you should train your employees on this policy so that they understand clearly that it is not permitted, even if they are registered and permitted to do so under state law. You can enforce neutral policies regarding drug testing and zero tolerance. Most employers have these policies. And you need to apply it in a non-discriminatory manner. That is, if you're going to test for drugs, you need to do it on somewhat of a random basis or a plain basis so that you're not just targeting people that are registered. If those are the only people you're testing, you may run into some complaint that is discriminatory. You are still able to discipline employees for violating a workplace drug policy. And what this means is if you have a workplace drug policy that says you cannot use drugs at work or be under the influence of drugs at work, that would apply to marijuana and more specifically to medical marijuana. So if you have an employee who tells you, I'm a registered user of medical marijuana, I'm permitted to use it, you can say, well, that's fine. But if you are under the influence of it or using it at work, we're going to treat it just like we do any other drug that's illegal because, in fact, for federal purposes, it is illegal. And so you still have your right to discipline employees for that. If an employee fails a drug test, even if it's for medical marijuana, you can discipline that employee just as though they were not registered under the Act. And you can adopt reasonable regulations or policies concerning how it's consumed, stored, and so on. Now, as you can see, this is a point where you have to make a decision as an employer. Are we going to permit it to be on our property? Are we going to permit it to be consumed? Or are we going to prevent it from being stored on our property and prevent it from being consumed? And as you make that decision, keep in mind, as I've repeated many times, it is still absolutely illegal under federal law. Although I will tell you that Attorney General Holder had announced that the federal government does not intend to prosecute people who are licensed and registered under various state laws for use of medical marijuana. That still doesn't make it legal. It just means they're not going to prosecute those cases. That may change as sometime when there's a different Attorney General and a different administration. You can prevent your employees from working while impaired, and you can terminate employees who are impaired even if the impairment results from the use of medical marijuana. Nothing has changed in that regard. In other words, if you have a policy in that way, here's a fellow that's having a good time. Stop arresting patients, you can see back here. And this is part of the movement, but it doesn't change anything with respect to your policy and your right to terminate employees who are impaired for any reason. So what is impaired? And these are actually definitions that are found in the Act. Impaired manifest specific articulable symptoms that decrease or lessen his work performance. It's basically, you know what impaired is when you see it, I guess, because you have to observe symptoms that are causing the employee to not work as well or perform as well as they would otherwise. Give a few examples of this. Speech, obviously, slurred speech or strange speech, I guess. Changing the way they move physically, their coordination, dexterity, their demeanor, how are they acting? Are they acting strange, acting irrational or unusual? Are they being negligent in how they're carrying out their job, and especially people that are working around equipment and machinery? Are they concerned about the safety of others? And then you have, of course, those instances where you have an accident that causes damage to equipment or property or even other people, and that's going to be a trigger for you to probably test that person. Are they disrupting production, being careless, and those sorts of things. Now, if you, under the Act, if you opt to discipline an employee for being impaired on the job, and we're talking about people that are impaired as a result of medical marijuana, because those are the only people that are covered by the Act, you have to give the employee a reasonable opportunity to contest the basis of the determination. In other words, it could be that what you observe is the result of prescription medication or some other reason, illness. It could be a number of things that are not the result of being impaired from the medical marijuana. So this is what you might call due process. In other words, the right of a person to sort of tell their side of the story. This is an interesting part of the Act, and I'm not sure how it ended up in the Act, but it's a good thing for employers. What this says is that the employee cannot bring a cause of action against you if there was a good faith belief that the employee used the marijuana on the employer's premises or during work hours, or was impaired, and this is where the definition of impaired becomes important, was impaired on the employer's premises while during work hours. So this is saying that you can't be sued if you had a good faith belief that one of these two things was occurring, and I encourage you in these situations, as I do in all employment situations and discipline situations, is to document everything heavily at the time it's occurring and make sure you have a good and full written record of what's happening, including possibly statements from people about what they've seen, what they've observed, and you want to build your defense as you go. If you don't, I've seen many times in many cases where juries simply don't believe that something happened because nobody wrote it down. And so I encourage you to document that as you go. I'm having a little problem getting, here we go. Let me back up here. I'm not sure whether this is going slow. It may be my computer. But this is an important aspect of the Act that provides further protection for employers. It's clear there is no cause of action against an employer if the employee injures or causes a loss to a third party. If the employer had no reason to know and did not know that the employee was impaired. And this goes back to the impairment definition that's so important. And so many employers that may be listening to this have employees who travel, who go to other places, maybe in company vehicles, maybe not. And so there's an increased risk of injury to a third party by an accident. There is a defense for you if you can show you did not know of an impairment. Now, while Illinois doesn't have a lot of cases, or really any cases yet under the Act, we can get a sense of what Illinois may do in cases by looking at other states who have had this a little bit longer. And one of those cases, as you can see there, is Coors Beer. And in 2013, last year, this is a federal case in Colorado. They had an employee that tested positive for marijuana, fired for violating the drug policy, and the employee responded by saying, well, I never used the drug at work, and I wasn't under the influence of the drug at work. Therefore, just because it was in my system from use outside of work and I was not impaired, the court says, no, if you have a positive drug test, even if it's from medical marijuana, it's okay to fire the employee. And the reason for that was under Colorado law, there was a specific provision in the Act that said the employer need not accommodate the medical use of marijuana in any workplace. Illinois has that same, same provision, and therefore we believe that an Illinois court would find the same based on this law. In other words, if you have an employee that tests positive for drugs, you can terminate them even if it's medical marijuana. But I encourage you, if you apply that rule, that you apply it in a situation where everyone who tests positive, regardless of what it is terminated or not, because otherwise, if you only apply it to the medical marijuana people, you could have a claim of discrimination. You're only targeting them. So as I said, Illinois has adopted that specific language in the Act that says you can discipline an employee, that slide should say, for failing the drug test. We think it'll be the same result in Illinois. So let's talk for a moment about the ADA. The Americans with Disabilities Act is a federal act that provides under certain circumstances an employer must provide some reasonable accommodation to qualified individuals, and that's a topic for another day of what all that means. But what you need to know for the purpose of this discussion is that the Americans with Disabilities Act treats testing for illegal drugs differently from testing for legal drugs. And if you're testing for legal drugs, that is considered what's called a medical examination under the Americans with Disabilities Act and requires certain steps to be taken and certain rules must be followed. However, if you're testing for illegal drugs, the Americans with Disabilities Act does not apply. So the question becomes, well, is medical marijuana, which is legal in Illinois, is it considered a legal drug under the ADA and subject to all those rules, or is it considered an illegal drug? Well, you use federal law to determine this answer because the ADA is a federal act. It's not a state act. And therefore, if it's illegal under federal law, then it is considered an illegal drug under the ADA. An important question. You can test for it under the ADA, even for medical marijuana, and that should not change anything that you do. This is my favorite picture in the slideshow, and here's a dog that hangs with his buddies. The ADA looks to federal law and that's state law, so that should not be a worry for you or a concern in terms of the ADA. Under federal law, marijuana is an illegal Schedule I drug. As I mentioned earlier, the DOJ, Department of Justice, announced in 2009 that it did not consider state legalized medical marijuana use a crime to be prosecuted. And I am not aware of any case in which a prosecution has occurred of somebody using medical marijuana. Of course, we don't know what will occur in Illinois because we don't yet have registered users. However, DOJ, having served as the U.S. Attorney, there are 93 U.S. Attorneys in the United States. They respond directly to DOJ and to the Attorney General, taking guidance from them on who will be prosecuted and who won't be. Technically, U.S. Attorney has a right in his or her district to prosecute those cases it wishes to, just like a state's attorney would in a county. However, guidance from Washington on what should and should not be prosecuted. However, as I said earlier, we have an administration in place now that has taken that viewpoint. The next administration may say, we are going to prosecute these cases. The underlying illegality of the drug remains the same, whether it's prosecuted or not. It is still considered illegal, but just not prosecuted. And so really, this doesn't change our analysis, the fact that they're not prosecuting it. The question isn't whether it's enforceable or being enforced, it's whether it's illegal as you determine this. Let's take a look at a case here from California. And in California, which has had this law for some time, the Supreme Court of California said an employer may lawfully terminate an employee, and I will underscore here something important, refuse to hire an applicant who tests positive for marijuana, even if it's marijuana used for medical purposes and legally used under California law. So the employers in California, and as we've seen in Colorado, still have the right to treat it as an illegal drug in terms of discipline, refusal to hire, and all those sorts of issues. Okay. The question then becomes, what lies ahead for this whole issue? Well, you can see here are two lawyers that are fighting, and I put this slide in here because I think what we're going to see is a tremendous amount of litigation occurring in Illinois once the program's up and running, and we're going to see a lot of probably divergent opinions throughout the state in the various courts that are going to end up probably in our Supreme Court deciding some of these important issues and so on. Now then, I want to point out a couple of things here that are not in the slideshow that I think are important. One of the issues that has come up is the use of medical marijuana and also having a permit, a FOID card for ownership of a gun. And when the act first came out, the position was that if you wanted to become a registered user of medical marijuana, you had to surrender your card and could not own a gun. Since that time, the regulators, and there are tremendous regulations that go with this. I encourage you to go online, and if you don't have anything else to do, read the many, many, many pages of regulations that go along with this, and the very long act as well. But so those restrictions have been dropped, and a person can now own a gun and at the same time be a registered medical marijuana user. And that was a big change. However, that doesn't mean that Illinois residents can own a firearm and be a registered user. And the reason for that is just what we've been talking about throughout this time together, and that is that federal law still bars ownership of a gun to anyone who uses marijuana or other controlled substance. This is a problem, and this is one of those areas of conflict that that we are seeing. So the sum total of what we're saying today is this: as an employer, nothing really changes for you unless you choose to change it. You have hopefully set up a good program, a good policy for drug testing, for preventing use and presence of drugs in your workplace. Nothing's changed with respect to that, and you do have some protections under the Act, but each employer is going to have to decide what they will and will not permit on their premises, and what they permit or don't permit their employees to do. It's estimated we're probably going to see about in excess of about 10,000 qualified Illinois patients. I don't think we're going to see just huge numbers of people just getting medical marijuana just for fun. The truth is, even though I prosecuted a lot of marijuana cases over the time I was with the government, the truth is that there is a value to medical marijuana when it's used properly. The medical marijuana actually, as I understand it, has a much lower chance of, as we say, getting you high than normal marijuana, because the part that's important for the medical part of it is not that part that causes you to get high. So I don't think we're going to see a lot of people just lining up to use marijuana in a recreational way by getting this. Obviously, there are going to be some people who abuse this. We see that in everything. But I think by and large, it's going to be restricted to people who really do have a medical problem, and that's going to be an issue for employers to decide how are we going to handle this in our workplace. So it's a brave new world out there. We'll see what happens and keep an eye on it. I encourage you to go to the website of various groups that talk about this, and you can see how the fight is starting to sort of come together, and there are going to be a lot of issues and a lot of decisions that will have to be made as this thing ramps up. So,
Courtney, there is a few questions, if I can interrupt.
Please.
The first one says, what if a customer is smoking on your property or parking lot? Can you evict them?
Yes. Yes, you still have the right to remove people, whatever the illegal drug is. And again, you can, whether it's medical use or not, you can remove them from the property. I will say that it's unlikely that a person's using it for truly a medical purpose is going to want to be in a parking lot or in your business doing that. I think they're more likely to do that at home if they're truly using it for medical purposes. But you see somebody using an illegal drug, including medical marijuana, you have the right to remove them from your premises.
All right, the next question, is there a difference for local government employers?
I don't think so. I think that local government employers would be treated the same. I'm not aware of a difference in the act for them and how they treat this. It's local government employers. In fact, I think that since it is federally illegal, may even have a bigger problem by allowing it because of various contracts or perhaps grants and so on from the federal government that they may be seeking. So you want to be particularly careful that you're not violating any federal laws that might affect federal grants.
All right, next question. Can they have a driver's license and be registered medical marijuana user?
As far as I know, there's no restriction on driver's license. It'll be interesting to see how the police treat this if a person's under the influence of marijuana while driving and it's medical marijuana. And as I said, you're less likely to be high using medical marijuana just because of the way it's grown than you are normal marijuana. But I don't yet know how the police are going to treat that, but it would still be, as I said, federally illegal, and they could, I think, prosecute that for impaired driving.
All right, the next one. What if an employee states that the use of medical marijuana does not impair work performance, but also enhances? Wouldn't the definition of impairment change?
Well, that's interesting. Read that last part if you would, Aaron.
It says, wouldn't the definition of impairment change?
I don't, I mean, I think impairment is so, the way it's defined in the Act is so general in a way. It's if you observe somebody who's under the influence. But if we look at these cases, they say that if a person has the drug in their system, even if they're not impaired, you can terminate them for a positive drug test. So in terms of discipline or termination, it's not going to make a big difference in terms of whether they're impaired or not. In other words, they can't say, well, this is actually enhancing my job, and I have it in my system, so don't fire me. I think that the question is not whether they're being impaired. The question is whether or not they have it in their system. And the cases from California and Colorado that we talked about demonstrate that. However, the impairment becomes important in terms of your liability or potential liability to third parties and that sort of thing.
All right. Are there any implications for Missouri employers that have employees who live in Illinois?
That's an interesting question. I haven't had that question come up, and I'm glad it was asked. I don't know. I don't think Missouri is one of the states that has this act. I may be wrong about that. I will say that if you have an employee who lives in Illinois, who's registered, who comes to Missouri and has the drug on them, for federal purposes, it doesn't matter what state you're in. So if it's illegal in Illinois, it's still going to be illegal in Missouri. And I would think that the analysis we've applied here in Illinois would be equally applicable in Missouri because of the federal the federal government. It's illegal in every state. And so I don't think the analysis is going to be very different. But I'm going to have to look at that more closely because I'm not certain what Missouri's law is on medical marijuana.
All right, next question. How do you determine, other than physical signs, that a person is under the influence? Marijuana stays in the system longer than, say, pain pills. Are their levels test similar to alcohol?
There are tests, various ways to test for marijuana, including a hair follicle test, which would be, or a hair test, which would, I think, is good for maybe 6 months or more when you test for it. So again, there's a difference between being impaired and having the drug in your system. Impairment is determined by what you see, hear, and observe. And the test for the marijuana as to what's in the system, you're not so much concerned with the amount of it, whether it's present or not, that would trigger discipline or termination. However, I think that the level of marijuana in the system can be determined by various tests that are available.
All right. Some people are also wondering, are you going to share this PowerPoint presentation so it can be printed off? I know we'll have the recording, but do you typically share the PowerPoint?
I'm happy to share it. I do need to correct my misspelling of one of the words. I see that, but I'd be happy to do that if they would like to send me an email asking for it. I'd be happy just to send an email back to them with a copy of the PowerPoint. And I don't know, it's my email address. I don't see it on here, but it's pretty simple. It's ccox, C-C-O-X, at sandbergphoenix.com, and that's all one word, Sandberg Phoenix. You can see it on your screen at the bottom left corner. And you can also go to that website, and you can find my email address there, sandbergphoenix.com, and you can find me on there, and it will have our email address. I would also tell you that on our website we do have a employment law blog that we frequently add articles to on different areas of employment law, and you might want to check that out and see some of the things we've talked about there, including this topic. So if you'd like to have a copy of the PowerPoint, I'd be happy to send it to you. Just drop me an email.
Okay, there is one more question. How will this be treated under the Illinois Human Rights Act? Could they have a case at the state level?
The Illinois Act also has a provision similar to the ADA, or in other words, it makes it illegal to discriminate against a person because of a disability. I don't know the answer to that. I've talked with some people about that, and I've not seen anything on the internet or any discussions in which they talk about how that may be handled. And I think there's a real problem for the Department of Human Rights in handling these claims, because here you have a person who's violating the law. They're engaged in a criminal act, even though under Illinois law it's permitted. We're in a schizophrenic state here, and in the sense that it may be okay under Illinois law, but it's still a crime. And basically the department would be saying it's okay for a person to engage in a violation of federal law, and for you not to punish them for that. You know, it just doesn't make sense, and I think they're going to struggle trying to figure out what to do with it. I don't know yet, and I haven't found anybody that has an idea. We just haven't seen a case yet. It's a good question, though.
All right, we'll wait about another minute if anyone else has any questions that they would like to submit. Otherwise, I'll be reaching out to everyone with the copy of the recorded webinar and also Courtney's email address, so you can reach out to him directly if you want a copy of the PowerPoint.
All right, thank you all for listening.
All right, thank you, everyone. Thanks for attending today, and have a great rest of your day. Thank you, Courtney.
Thank you. Bye-bye.